Hi, this is Dan Smith, and welcome to today's episode of Business is More Exciting Than Any Game. What I want to talk to you today is about the Children's Online Privacy Protection Act, or COPPA, and how it relates to businesses that may maintain or operate a YouTube channel. Let's say, for example, you are in business. Your small business, part of its marketing strategy is making online videos that you upload and maintain on your company or your business's YouTube channel. Now, there's a federal law called the Children's Online Privacy Protection Act, or COPPA, and what it basically provides in essence is that if your content online is directed to children or towards children directed, then you are required to not make your content available to them, not get personally identifiable information from them unless you get express written permission from their parents if they are under the age of 13. So, for example, if you operate a YouTube channel or you have a website, but today I'm talking about YouTube channel. If you have a YouTube channel and your content is directed to children, and we'll talk about what that means in a moment. But let's just say, for example, that your content is directed towards children. Your business model is perhaps it's selling games to preschool children, or puzzles, or other business types of activities, who your ultimate customers would be children under the age of 13. For example, like I said, games, puzzles, things of that sort, videos, cartoons, other content that's going to be really sold to or directed towards children. If your content is children directed, and what that means is children under the age of 13, 12 and under, then you cannot make that available. You cannot get information from them, their names, addresses, anything of that sort, without getting written permission from their parents. So you can't, for example, put this content out and have a child under the age of 13 provide you with an email address or with a name or anything of that sort, which you might then later use for marketing purposes. Now, in a recent blog post that was put out by one of the people that works at the Federal Trade Commission, they talked about this issue of children-directed content on YouTube channels. And one of the things it talked about was what types of information would be personally identifiable information to a child under the age of 13. Now, I mentioned name, address, email address, that type of thing. But another thing that was pointed out in this blog post that the FTC put out was what they call persistent identifiers. That's something similar to cookies, which you get when you visit websites, which then can later be used to track a website visitor, so that you can then provide them with marketing information more tailored or specific to them based on the websites that they may visit, so that if you had a visitor to your website or to your YouTube channel, and you were able to collect a persistent identifier of that visitor, and then provide them with marketing information when they visited another site or that type of thing, that's the kind of information that is prohibited if your content is children directed under the age of 13, and you do not have the consent of the parents. So, what does it mean to be children directed? Well, some things are very clear, some things are not so clear. if your business model, your business plan is to sell goods or services that are really directed towards children under the age of 13, like for example I said preschool games, toys, puzzles, things of that sort, it's pretty clear that your content is going to be directed at children under the age of 13. You also, the FTC will also look at things like whether the content contains cartoon characters, the colors, the tone of the online videos or the content, whether it appears that it's the kind of thing that would appeal to children under the age of 13. So as a general matter, if you have a business and you operate and maintain a YouTube channel for your business, for your marketing, if your business is children directed, you have to make sure that you get written permission from parents before you collect any persistent identifiers or any information from your website visitors. So that's just something to keep in mind. It doesn't apply, this COPPA doesn't apply only to websites that you might have set up for your company, in which you may have very compliant. You cannot access this website if you're under the age of 13 without parental consent, and have a way for getting parental consent for a child to access your content. But with a YouTube channel, that might not be quite so easy. And what you have to keep in mind is that if you are tracking your visitors and getting this persistent identifiers to people who visit your YouTube channel, so that you can later remarket to those people, that persistent identifier that you're getting to show who's looking at your content on YouTube would be illegal and non-compliant with COPPA if your YouTube channel is child-directed and you're basically appealing and putting out content that's directed towards children under the age of 13. So if you do that, you've got to come up with some mechanism to get the parental consent to get information from your visitors, including persistent identifiers, or you're going to have to be careful not to obtain any information from your visitors. No names, no addresses, no email addresses, and no cookies, no persistent identifiers, so that you could later track those people and market to them. Okay, I hope that helps. If you have any questions, please feel free to call. Remember, business is more exciting than any game.